Hello, I'm Kelly Allen. I'm going to discuss with you asset protection for married couples. And when I say asset protection, I'm specifically referring to the situation where one spouse is in need of long-term care in a skilled nursing facility and we're needing to apply for Medicaid to pay the room and board at the nursing facility. So when we're dealing with married couples, we can really do a lot to assist because the number one concern generally is if my spouse needs long-term care at a nursing facility, that's going to cost $6,000 to $12,000 a month. So even if the couple has significant assets, privately paying, that's not going to last very long. And the concern is, how does the healthy spouse continue to live? Because if the healthy spouse is having to try to use all of their assets, all of their savings to try to pay the nursing facility bill, then most of the time there's not going to be much left for the healthy spouse to continue to take care of his or her necessities. So the good news is that most of the time we can assist the couple and achieve financial long-term care Medicaid eligibility for the spouse who is in need of long-term care and still protect or preserve most, if not all, of the couple's assets. Because the Medicaid regulations give a lot of latitude, a lot of ability to be able to do this. The problem is most people are just not aware of it. So we've talked before about the Medicaid basics, that the Medicaid applicant's income generally has to be less than the monthly cost of the nursing facility, and that the Medicaid applicant has to have less than $2,000 in countable assets. And we've discussed that the healthy spouse, who for some reason is called the community spouse, have no idea why, but that's the Medicaid term, the community spouse has a cap on the amount of assets that he or she can keep, but then that community spouse's income is unlimited. No matter what that healthy spouse's income is, it does not impact the spouse who needs care. It does not affect his or her Medicaid eligibility. So the good thing with married couples is that we're allowed to gift from one spouse to the other, and there's no penalty for doing that, even if it's within the 5-year look-back period. So if we have an asset, a bank account, a property that is in both spouses' name, then as we can move that into just the healthy spouse's name, and there's no penalty for doing that. Or if the asset is, let's say the husband is the one who is in need of care, and the husband has something that is in just his name, he can gift it. He can move it into the name of the wife, and there's no penalty for doing that. So we can very easily get the husband down to less than $2,000 in countable assets by simply transferring everything to the community spouse, the wife, in this case. So then we've already talked about that the wife can have unlimited income. So the only thing now we have to deal with is that limit on the wife's assets. And this is a calculation that has to be done. There's no set amount. But once we figure the amount of assets that the community spouse is allowed to have, then in general the concept is you want to convert assets that are keeping the spouse in need of care from qualifying for Medicaid and turn it into income. And generally we'll do this by having the healthy spouse, the community spouse, work with a finance company to purchase a Medicaid compliant annuity. So in general, let's say that there's $50,000 in the bank in wife's name, and that's what's keeping the husband from qualifying for long-term care Medicaid. We can in general have the wife purchase a Medicaid compliant annuity, which is a specialized product that you work with a finance company to purchase, and most of them do not handle Medicaid compliant annuities because this is an annuity set up just for Medicaid purposes. But the wife is going to write the annuity company a check for $50,000. Then she no longer has excess assets, so she's under her required limit. Then in exchange, the annuity company is going to have a contract whereby every month it's going to pay the wife a certain amount of money. Well, that payment from the annuity company is characterized as income, which we already discussed can be unlimited. So the wife has then switched out a countable asset, money in the bank, for an income stream. And when all is said and done, other than the fee paid to the annuity company, basically the wife has all of the assets back. So the husband is in skilled nursing, receiving skilled nursing care. Medicaid is paying the room and board at the facility. Wife still has her assets. She still has what she needs to live on. And so both of them are taken care of. It is exceedingly complicated. It is absolutely nothing that you should try on your own. You definitely need the assistance of an elder law attorney to prepare this type of case for you. But the main thing to know is that there is a lot we can do. If your spouse is in need of skilled nursing care, do not just move them into a facility and start privately paying, thinking that you have no other option. Come and talk to us first so that we can look at your specific situation and see what we can do to protect those assets.